Welcome to Live at Lunch. Today we are talking about employment-based immigration updates in the United States as of September 9th of 2025. I just saw an email from a colleague that was discussing a recent change in immigration law, and he said, all that we can advise on, all that we know is what the policy is today. And I felt that in my soul. There are so many changes going on right now in immigration law, whether we're talking about employment-based, family-based, asylum, deportation, defense, it's a lot to keep up with. So today our focus is on recent changes that have either already happened or that are potentially in the pipeline for employment-based cases. I'm so glad that you have joined us, whether you're joining us live or catching the replay. I'm glad that you're here. If you have questions, comments, put them in the chat, put them in the comments below, and I will answer any questions as I can. As always, this is not legal advice, and I can't give legal advice through the specific forum. So today we're talking about 4 points. One is the interview location for immigrant and non-immigrant visas. That's the first 2 points. Second one is a proposed rule that has already been published by the Department of Homeland Security that would affect significantly the rules around F1 visas and J visas. So F is student visas, J is for intercultural exchange. And then finally, we will touch briefly on the potential proposed rule for weighted selection for H-1Bs. So let's get into it. My name is Emily Sumner with Sumner Immigration Law. Let's talk about this. So the first 2 changes that we're going to talk about today that are impacting or will impact employment-based immigration law. And I'm focusing on employment-based immigration law because that's primarily what we practice. We do some family-based as well. And because I've had so many clients over the recent months say, what changes are there in employment-based immigration law? And there have been some. A lot of the changes that we have seen have really impacted family-based immigration processing and individuals who are in the immigration court system. So this is for you if you have asked that question about what is happening. So first, the changes to the interview location. So the Department of State has announced recently, they announced at the end of August, that starting November 1st, any interviews for immigrant visas has to be done. All of those interviews have to be done at the applicant's place of residence or their country of citizenship or nationality. So the wording in this particular announcement from the Department of State is required. It's not something that's optional. It's not like, oh, we're going to, taper off on those. They're saying as of November 1st, the interviews have to be for immigrant visas have to be done in the country of residence or country of nationality. Again, that starts November 1st. So if you have an interview scheduled before then you should be okay and you should be able to go to that interview. But starting November 1st, those interviews have to happen for immigrant visas in your home country, in the country of nationality or where you reside. Immigrant visa refers to the process of applying for a visa to be a permanent resident in the United States. So if a person enters the United States with an immigrant visa, they should receive a green card basically as soon as they enter. Within a few months of entering the United States, they enter as a permanent resident of the United States. That is unlike non-immigrant visas, which are temporary visas for a person to stay in the United States on a temporary basis. Temporary can be for a matter of years, depending on the visa classification that you have. But that brings us to our second point, which is the change for non-immigrant visas. The Department of State recently announced, just within the past couple of days, that interviews for non-immigrant visas for these temporary visa classifications should be held in the applicant's country of residence or nationality. So that eliminates basically the option for what's called third country processing, or third country national processing. So in other words, there's this concept, it has been a thing for a long time, where a person is able, especially since COVID hit, it has always existed, but especially since COVID hit, there's been some more flexibility in where a foreign national can apply for a US visa. In other words, it did not necessarily have to happen in their home country or where they're residing. Couldn't happen in the United States. That was eliminated a long time ago. There was a pilot program for a short while in the Biden administration, but that has since stopped. So it always has had to happen in general outside of the United States, at least since the 9/11 event that happened anyway. feel like I'm kind of rambling here, but my point is that these interviews it was until recently, and this effect is taking immediately. The one for the immigrant visa is taking effect as of November 1st. The Department of State announcement for the non-immigrant visas, the temporary visa classifications, say that starting immediately, these interviews should take place in their country of nationality or residence. So that is potentially a problem, because until then, or until now rather, you could, a foreign national applicant who's applying for a US visa could go to another consulate, to another country. So for example, we have had clients over the years who have needed to apply for a visa for whatever reason. They're in the United States, but they need a visa, which is the physical document in their passport that allows them to enter the United States. And they've been able to go to posts in the Caribbean, for example, which is a relatively short trip away from where we are here in Central Virginia. So that is no longer an option, according to the Department of State, according to this announcement. So those are unfortunate developments. There are certain exceptions, both for the non-immigrant visa classifications and the immigrant visa classifications. There are certain countries where we, the United States, do not have a operating embassy or consulate. So the Department of State has specifically listed alternative locations for certain countries where we don't have operations. But otherwise, starting November 1st for immigrant visas and starting now for non-immigrant visas, generally speaking, you have to have those interviews done in your home country. That is not a great development, because previously we were able to potentially select another country if there was a long wait time, or if there was another reason that it would be advantageous to apply for a visa in a country that you're not living in or have ties to or are a citizen of. So those are unfortunate developments, but we are here. We will help you get through this. The next situation that I wanted to talk to you about, the next development I wanted to mention, point number 3 here, is the proposed rule for F and J visas. So the F visa, you may know, is for student visas. That is for national students who are studying at approved universities here in the United States. J1 visas are to facilitate intercultural exchange, and they're used for all kinds of things. They're used for au pairs, meaning nannies who take care of children and families here in the United States. They're used for short-term and long-term research scholars. They're used for teachers, a lot of times have J1s for national teachers. And in addition, people who are here to experience the American culture. So sometimes people will come here to work, for example, at a theme park or another place like that. I've seen them at restaurants, who are here for a specific period of time to experience the American culture. Anyway, this proposed rule does affect potentially, and it is a proposed rule, but it affects individuals who are or will have F1 or J1 visas. There are a lot of changes in this proposed rule. So high level, this proposed rule, and when I say rule, I mean regulation. So each agency, federal agency, develops their own set of regulations to implement the laws that are written by Congress. So this is a proposed rule. It's a proposed change in the regulations and the agency's regulations. This is from Department of Homeland Security, and again, it would affect F1 and J1 students. So J1 visa holders, not necessarily students, because you're not necessarily a student on a J1, though you can be. So it's a proposed regulation. The just high level view before we get into what this regulation says. When a regulation or proposed regulation is published, generally speaking, according to the Administrative Procedures Act, the regulation is, or the proposed regulation is published, and that has happened. We actually have the proposed regulation now, unlike my 4th point that we're going to talk about. But we have the proposed regulation. There's a comment period. So stakeholders, anyone who's interested in this, can submit comments to the regulatory agency, in this case to the Department of Homeland Security, to give your feedback, to let them know what you're concerned about, let them know what you support, what you don't support. The agency is supposed to review those comments. That doesn't mean that they have to agree. Of course, they're not going to agree with every comment that's submitted. They may not agree with a lot of the comments submitted in this particular situation, but they have to review those comments and either incorporate changes or at least consider those comments. Then they publish what's called the final rule. When they publish the final rule, generally speaking, there has to be a future start date for the regulation. So a lot of times, when a final rule is published, it will become effective 60 days from the date that final rule is published. So my point here is that right now, until September 29th, we have a 20-day period to submit comments. And if you are concerned about this, or if you have thoughts about this, I absolutely encourage you to submit comments. I will try to remember to put the link to submit comments in the comments below this video. But submit your comments, submit your thoughts so that they can take that into consideration when they're making the final rule. Again, they may or may not agree with any given person's comments, but it's worth a try. So what is happening in this regulation? There are several key points in this regulation, and this is a summary, and I am referencing notes because I haven't memorized it all yet. So first key point is that there would be a fixed date to the admission period. So right now, when a person enters the United States in F1 or J1 status, they are admitted for what's called duration of status. So if you or a friend or family member is here in the United States on F or J status, on your I-94, which is your entry record, it will say, when it says, there's a place that says how long you have to stay in the United States, it says D/S. That means duration of status. That means as long as you are maintaining status, as long as you're attending school or maintaining your J1 program, you can stay in the United States. This regulation would change that so that you are admitted for a fixed date. And that's true of other visa classifications right now. So for example, if you enter on H-1B or E3, E2, TN, you are admitted until a specific date. So you would be admitted to a specific date instead of having the duration of status. That specific date should correspond with, according to the regulation, should correspond with the program end date on the Form I-20 or DS 2019. Those are documents that are relevant to the F1 and J1 program, respectively. In addition, the admission date, the regulation says, should not exceed, or cannot exceed, not to exceed 4 years. That's incredibly important because I have so many clients and have had so many clients over the years who have entered the United States as an F1 student, even in high school. I have family friends who have entered in high school. Now they're in college, they plan to go to graduate school. So it's absolutely possible to legitimately be in the United States for longer than 4 years in F1 status. But this proposed regulation would limit the duration of your F1 status to a maximum of 4 years. Also, importantly, it would shorten the grace period from 60 days to 30 days. So for F1 students. So right now, the F1 students have a grace period at the end of their program. Once they graduate, they can have what's called OPT. But if they just decide to leave the United States or at the end of their OPT, they have a grace period of 60 days. They can't work in the United States during that time, but they have a period of 60 days to travel, to visit friends, to wrap things up, perhaps to, in their lease, sell their car, whatever it is they're going to do. This regulation would change that from 60 days to 30 days. In addition, point number 2 about this proposed regulation for Fs and Js is it would require a formal extension process with USCIS in certain situations. So those situations include extending your program, changing schools changing from one institution to another, moving academic levels, using post-completion practical training, which is OPT, optional practical training. For any of those situations, and this regulation is pages long, so I'm not listing every single, word that's in the regulation or situation that's in the regulation. But for situations like that, the foreign national student, the F1 student, would be required, or potentially J, would be required to file what's called a change of status application or extension with USCIS. That's not required right now. In many situations, that's not required. Of course, to apply for OPT, optional practical training, or a STEM extension, students are required to file the application for the work permit, the Form I-765. This would be an additional step that students would have to take in a variety of situations. Filing an application with USCIS, there's an application filing fee. A lot of times people use an attorney for this, not always, but a lot of times they do because they want that extra guidance and support from an attorney to go through the process. The regulations also indicate that there could be a biometrics. They also say in the regulation that there could be an interview with USCIS. You could imagine how long it could take for these applications to be processed. So a lot of complications there. Another potential change with this regulation is a cap on ESL duration of admission. So ESL, of course, stands for English as a Second Language. Sometimes a person will enter an English language program first in the United States to get a solid foundation there. It's required to have a certain level of English proficiency to join other academic programs. So they would cap that English language training at 24 months. There would be a restriction on the transfers and changes of educational objectives, with graduate students prohibited from changing programs. And then there would also be a prohibition on lateral moves or reverse matriculation. So that means that if you have finished one degree level, the regulations would prohibit you from enrolling in a separate degree at the same degree level. So for example, if you have a bachelor's degree already, you would be prohibited from studying in the United States on an F1 visa to obtain a second bachelor's degree, and you could not go below. So let's say that you've obtained a master's degree and you want to go back and get a second bachelor's for various reasons, you would be prohibited from doing that using the F1 visa. So these are tremendous changes. These are really significant changes. They are not great, to be honest. They would create a lot of complications and delays, in my opinion. So if you have any interest in this at all, if you are a DSO at a school, if you are an employer, if you're a foreign national student, if you have a family member who is, I do encourage you to review the regulation as much as you can. I know that you're not lawyers necessarily, but review the regulation and really submit thoughtful and intentional comments about your concerns about it. Like I said, they don't have to adhere to them, but that's what we can do. That's what's within our power right now. The fourth thing that I wanted to touch on is potential changes to the H-1B cap selection process. So you probably have heard this floating around before. You've probably heard about it. The first Trump administration actually created a regulation very similar to this. This regulation, by the way, has not been published yet, so I don't have a whole lot to say about it because it hasn't been published. We have a general idea of what it would look like. We do know that it's within the regulatory pipeline. So we know that it's likely that a proposed regulation on this would come out soon, again, for a comment period. The first Trump administration changed the selection process for the H-1B cap. So the H-1B cap selection process now is done by lottery. It's done completely randomly. So, and it's a great question that a lot of clients have every year. They say, well, are my chances of being selected higher if I have this job title or this salary, or if I work in this location? My answer has always been no, because the selection has been done completely randomly. However, this regulation would change to a weighted selection process. The first Trump administration, like I said, had a regulation that was struck down by a federal court. So I'm sure it will be litigated again if and when this comes up. We'll have to see what happens. But with the first Trump administration, the selection process, this regulation said that the selection process should be based on the wage that a person is paid. So basically, it's more complicated than I'm saying right now. But basically, the higher the wage, the higher the chance of being selected in the H-1B lottery. And again, that's an oversimplification. But kind of gives you a general idea that it would not be a random selection. There would have to be more work done for the actual registration. We would have to select the standard occupational code. We would have to have the employer agree to a certain wage. Usually we work all that out after the registration. Sometimes we have that conversation before. Anyway, my point is, know that that's potentially coming, but let's take a deep breath. That is not what's happening right now. That regulation, as of right now, has not even been published, so we'll have to see what happens. Even when it's published, of course, I will put that information out, give you more information about exactly what the proposed rule says, how you can comment on it, things like that. I hope that you have found this information helpful. I know it's a lot of information. There's so many changes happening, and it's a lot for us as immigration lawyers to keep up with. But we're here. We are here to help you. We're not going anywhere. We are here to help support for our nationals, their employers, their family members. We are here to help you get through this. If you have questions, please put those in the comments. Like I said, I'm happy to help as much as I can. If you are interested in talking to us further, if you have questions, if you are thinking about starting a case, we're here to help. I'm going to have an outro slide, meaning a slide after this, that has our contact information for how to contact us. You can send an email, set a time for a consultation, and we're happy to help. If you found this information helpful, I hope that you will share it with a family member or a friend. Share this video. Make sure that you subscribe to our channel. I would love for you to like this video. add a comment so that it reaches the eyes of other individuals. We're trying to get as much information out as possible to help provide clarity in this incredibly complex and challenging environment. My name is Emily Sumner with Sumner Immigration Law. We help individuals, employers, and families with employment-based and family-based immigration matters from around the United States and around the world. Until next time.